Ինչպես այսօրվա միօրյա սեմինարը, որ կազմակերպված էր Միացյալ Մարմնի հատուկ հանձնախումբի կողմէ պահանջադրություն հայրամյակեն ետք խորագրով, մեր սիրելի կերաբայձարը իր աղոթքով անշուշտ օրտնես անիգա ամբողջ օրվա ծրագիրը օրտնված կլա ներառյալ գեսօրվա ջաշը։ Մենք կսկսենք հայդակրի երկրորդ մասը, ուր ունի 3 տարբեր բաժիններ ըստ դրված հայդակրին։ Բայց սկսել առաջ ինձ համար հաճույք է գլենդել քաղաքի հայահոց գլենդել քաղաքի մեջ կազմակերպելով աստենարգը մենք ուրախ ենք, որ մեզ է դունենք նոր հանգստյան գոչված քաղաքապետ եւ ներկայիս քաղաքապետարանի անդամ անցնող 11 տարիներուն այդ պաշտոնը գվարե բարոն Արան Աջարյանը։ Ողջունենք իր ներկայությունը մեր մեջ եւ ուրախ եմ, որ բարոն Նաջարյան անցնող 11 տարիներու ընթացքին 3 անգամ ընդրված է եւ հաջող սեվով վարած է այս քաղաքի քաղաքապետի պաշտոնը։ Ինձ համար մեծ հաճույք է բարոն Նաջարյանը հրավիրել, որպեսզի քաղաքի անունով ողջունե այսօրվա մեր սեմինարը։ Մստր Նաջարյան։
Բարևձեզ, քանի խոսք անգլերեն պիտի ասեմ այսօր, որ եթե լսած ես իմ հայերենս, արդեն գլսես իմ այդքան մաքուր չէ։ But anyways, ladies and gentlemen, on behalf of the city of Glendale, I am proud to welcome this esteemed group of attendees and participants to this seminar, which is of critical importance to the Armenian community. Yes, we always push for recognition of the genocide, but as you've been discussing, what next? And this seminar discusses what next. I'd like to extend a warm welcome to our guests who have come, some from very far away, Professor Theroux, Mr. Arapapyan, and seated before us we have our esteemed group of panelists for this next session, Karnik Kirkonyan, Edvin Minasyan, and of course, the one and only Garo Gazarian, whose moderating skills are second to none. And I understand he did some moderating between the Los Angeles Police Department and some marchers yesterday. So thank you, Garo, for your efforts. As well, yes, thank you. Let's hear it for Garo. As well as to the representatives of the Armenian political parties that truly keep this community together and keep this community active. The Armenian Revolutionary Federation, the Armenian Liberal Democratic Party, the Hunchakyan Party, as well as all the other moderators, John Kosakyan, David Samelyan, Armen Hovanesyan, Ara Aharonyan. Thank you for coming. I know that this will be a very productive event, and I thank you all for coming. This is something that's being recorded, and we will continue our fights and our efforts until we see justice. Thank you, everyone.
Before we start our next panel, of course, I have to make an announcement, and of course, we have to be honored that Armenia, My Love movie will be opening next Thursday, a film by Diana Anderson. Diana, and she is the producer. She's the producer and director of that movie, and she's with us today. We welcome you all, Diana, because the movie is about the Armenian genocide, and she's acting in that movie herself. Good luck, Diana. Սկսելու համար սեմինարի երկրորդ բաժինը, ինչպես որոշի 3 մաս ունի, առաջին բաժինը կփականա բանջարության իրավական մոդեցում, որ արդու ներկայացվեցավ մեր շատ հարգելի հյուրերուն, որոնք հրավիրած էինք Բարոն Բաբյանը եւ պրոֆեսոր Հարի Թերիոն, որոնք ներկայացին եւ դուք վայելեցիք, ինչպես նաեւ այդ բաժնի ծևում հաղորդավարը մեր շատ սիրելի Արմեն Հովանեսյանը, որ գդալակորձեց իր մասնակցությամբ առաջին բաժնի համատրումը։ Իսկ երկրորդ բաժինը իրավական բաժինն է այսօրվա հայդակրին, որում պիտի մասնակցին Չիկագոյեն ժամանած բարոն իրավապան Կարնիկ Կերկոնյանը եւ իրավապան Էդվին Մինասյանը։ Իսկ հայդակիրը պիտի համագարկե իրավապան Գարողազարյանը, որ արդեն բարոն Նաջարյանը թրվադեց իր մասնակցությունը ասկաղութի յանքենես։ Ես իր համերությունը վերավորած չլալու համար խնդրեց, որ շատ չի վերավորին եւ իրեն գովապանություն չունեմ իր մասին, բայց ստիպված բիդնեմ, որովհետեւ բարոն Ղազարյանը մեր բարեկամը լալեն բացի նաեւ գզարայի մեր համայնքին երբեմն առանց ակնկալություն ունենալու, որբեսի զինք գովապանենք, բայց ուրախ եմ, որ ինքը համահայտնաբետն էր հայկական ցեղասպանության այս կավուտի հարամյակի միացյալ հաստախումբին, անիկա նախկին ադենաբետն է հայ իրավապաններու Ամերիկայի ընկերակցության, ինչպես նաև ներկայիս գզարայի որպես Civic Service Commissioner գլենդել քաղաքենես 2011-ին սկսյալ եւ ուրախ եմ, որ իր ծառայության շրջանը երկարացկված է քաղաքի մեջ։ Վարդկտ կադար սիրելի գարու։ Ինձ համար մեծ հաճույք է հրավիրել այս բաժնի համադրումը կատարելու համար Գարողազարյանը որպես իրավապան, որպեսզի գեսօրվերջվա առաջին բաժինը իր համադրումով սկսենք։ Գարողազարյան, հրամեցեք։
Բարև սիրելի հայրենագիտներ, առաջին հերթին ուզում շնորհակալություն հայտնել Միացյալ Հայ Մարմնի իր զույգ ադենաբետներուն, այս ծրագրի կազմակերպիչ մարմնին, նաև ցեզի բարոն Արոնյան եւ ողջունել մեր 100-ամյակե ավելի աշխատանք տանող 3 հայ կուսակցություններու ներկայացուցիչներու ներկայությունը այստեղ այսօր։ Երբ կխոսենք իրավական տեսանկյունը հայոց ցեղասպանության, ես շատ գարժորեն կուզեմ արտահայտվել այն զուգահեռ բնույթին, որ գոյություն ունի ցեղասպանության բանջարության եւ այսօրվա Արցախյան ազատագրման ապահովության գործողություններու միջև։ Մենք 1.5 միլիոնի չարթի նման թուրքերու կողմէ ագանադես կլանք ազերիներու գերդած ամմարտկային արարքներուն ավասիկ 1988 թվականին ի վեր մինչև այս տարվա այս ամսվա առաջին օրերը։ Այս բոլորը կկատարվին Թուրքիո բացահայտ օրհնությամբ եւ եթե Ադրբեջան գոչեցյալ այս երկիրը իր գարձիկով գործողություններ կկատարե իր իսկ հայդարարած իր դարածքը վերաստանալու ես կդադամսիմ մեկնաբանել որն է այդ ազատագրման գործողություններու կարևորությունը երբ ագանադես կլանք մենք հայ ձերունի զույգերու մարդասպանության ագանչի գդրելու գործողություններու որ ենթակա եղան որն է արդարությունը կամ հողեր ազատագրելու բահանջքը երբ կտեսնենք անխնար ըմբագոծում Արցախյան գյուղերու վրա երբ կտեսնենք 12-ամյա հայ մանուկի սպանություն եւ որն է արդարություն կամ ազատագրում իբր թե Ադրբեջանի կողմէ երբ կտեսնենք իրենց իսկ նախագահ գոչեցյալի արտահայտությունները 2002 թվականին մինչև օրս, որ կհրահանքե եւ կհայտարարե, թե համայն հայությունը թշնամին է Ադրբեջանի։ Այս արարքները, ինչպես նաև հայ քաղաքացի եզդի ցակումովի գլխադումը վերջերս ցավոք սրտի չարժանացան միջազգային արձագանքի, ցավոք սրտի Ռուսիա կողմէ դրամատրված զինամթերքները կամ այս վերջի օրերու դեղեցությունները Իսրայելի կողմէ դրամատրված զինամթերքի առնչությամբ չդադարեցան մինչև օրս։ Մենք բայց սիրելիներ տեսած ենք Նախիջևանի հայոց հողազրկումը եւ այսուհետև եւ այնուհետև մենք իրավունք չունենք նույնիսկ ապմը հող զիջելու որևէ մեկ թշնամու ըլլան թուրք, ազերի կամ ուրիշ։ Ուրեմն Արցախի ինքնապաշտպանությունը համայն հայության հայկական հողերու վրա կոյադևման պատերազմն է։ Եվ այդ պատերազմը մենք անհրաժեշտ է որ հաղթենք։ Եվ այդ պատերազմը գոյություն ունի կշարունակվի եւ դժբախտաբար դակավին չէ ավարտած, թեպետ զինաթաթար բառը կլսենք, որովհետեւ այդ շարունակությունն է մեր Արևմտյան Հայաստանի հողազրկման նման արարքներու Թուրքիո աչագից Ադրբեջանի կողմէ, Թուրքիո օրհնությամբ եւ օգնությամբ։ Ես կհուսամ, որ Հայաստանի կառավարությունը օրմը շուտ կջանչնա Արցախի ինքնակառավարման, ինքնորոշման անկախության հռչակումը եւ ինչու՞ չէ օրմնալ շուտ ինչպես Պարոն Փապյանի գարձիկն է գխորիմ միանա եւ դառնա միացյալ հայկական հողամաս մեկ թրոշի տակ անկախ ու ազատ։ Այսօրվա մեր գործընկերները հայրենապանական միության իմ սրտի շատ մոտիկ երկու երդասարտներ են։ Առաջինը ես որու հանդեպ ունիմ անսահման սեր եւ խոնարհում, որու ղեկավարության ներքո ես գործած եմ իմ առաջին ծառայությունս իբր իր փոխ ադենաբեդը դարիներ առաջ հայրենապանական միության։ Էդվինը անցմն է որ 17 տարեկանին Միացյալ Նահանգներ ժամանած է առանց իր ընտանիքին, ավարտած է USC համալսարանեն եւ այնտեղ նա ընտրված էր նախագահ միջազգային աշակերտության գազմի, ունի մագիստրոս տիտղոս իրավաբանական Լոյոլա իրավաբանական համալսարանեն եւ հիմնադիրն է Tannenhaus Minassian եւ Adham իրավաբանական գրասենյակի, մասնակցանալով աշխատավորներու իրավունքներու եւ նաեւ ունենալով բադիվը ծառայելու իբր թադավոր arbitrator այդ հանգամանքի մեջ։ Ինքը եղած է երկու դարբեր դարաշրջաններով հայրենապանական միության ադենաբեդը, նաև ինքը ներկայիս անդամ է հայ Արարատ դարեցներու դան խորհրդի մարմնի, ինչպես նաև ինքը կղեկավարե հայոց Էջմիածնո եկեղեցու առաջնորդարանի իրավական հանձնախումբը։ Էդվինի մասին ես շատ բան կրնամ ասել, սակայն կսեմ հետևյալը։ Էդվինը մեր հայրենապանական միության աբակայի ծրագրերու հանձնախումբի եւ մեր բանջարդիրական ենթահանձնախումբի երկար տարիներու ղեկավար ադենաբեդ եւ գործունյա անձնավորությունն է եւ մենք ուրախ ենք որ Էդվին ընդունեցիր այսօր մասնակցելու մեր հայրենագիտների հետ այսօր։ Վերադառնալով իր գողքին նստած Քարնիգը յուրահատուկ անցմն է, որովհետև Քարնիգին զույգը իր ոչ դարեգից զույգը, բայց զույգը, եղբայրը, մենք ամեն օր բադիվ ունենք եւ հաջիկ ունենք գիսվելու իր հետ մեր առօրյա կյանքը Սարո Քերքոնյան, շնորհակալ եմ զգուծարայության համար։ Կարնիգը ունի այնպիսի դիտողներ, որ ես բարերը չեմ գտնար գտնել հայերենով եւ անոր համար անգլերենով պիտի արտահայտվիմ Կարնիգի մասին նախքան հրավիրելու մեր այսօրվա բանախոսները։ He holds an AB magna cum laude in government from Harvard University, and he holds 2 law degrees, a JD from the University of Chicago Law School, where he served on the law review, as well as a diploma in international law from Cambridge University, England, where he studied under Professor James R. Crawford, now judge of the International Court of Justice. Upon completing his studies, Karnik Kerkonian joined Mayer Brown LLP in Chicago, working on litigation and appellate matters, and in 2003 began his own practice, now in its 12th year, focusing on international and corporate law transactions and foreign commodities exchange equity acquisitions. Now you know why I couldn't translate all of that in Armenian. I don't even understand most of it. He has presented on a number of international legal issues, including the economic analysis of sovereignty, the normative foundations to international law, the legal status of the Armenian Court of Jerusalem, as well as issues involving the International Court of Justice jurisprudence. Currently, he serves as a member of the Board of Governors of the Armenian Bar Association, and what's funny is that he's supposed to be co-chairing the Armenian Rights Watch Committee with me, but I can assure you all of the brain trust that exists in the Armenian Rights Watch Committee exists in one chair, and that's Karnik Kerkonian. Thank you, Karnik, for being here. We have been studying and studying and studying genocide reparations issue. I assure you, ladies and gentlemen, we have been for quite some time. It is very troubling, and there are some limitations and obstacles that these 2 gentlemen know far more and far better how to express and share with you. And with that in mind, I invite first Edwin to please commence your presentation. Thank you, everyone.
Okay, thank you, Garo. Thank you, the UACLA, the co-chairs, as well as all the members for organizing this. It's, always useful to get together and look at our common goal, common objective from different perspectives, and perhaps give us each other ideas. So we as the Armenian Bar Association, being actual practicing lawyers, we will try to address the same question as to reparations, a little differently than the panel that was wonderful earlier in the day. What do I mean by that? As we were talking with Karnik, and as I've said in prior speeches, we have the Armenian nation basically as a client. We're lawyers, practicing lawyers. And why don't we look at it as though a client walked into our office, sit at the chair, we had an appointment, and said, I have a grievance. Somebody owes me money. They owe money for compensation of the dead, compensation for confiscation of property, confiscation of and looting of an entire nation's cultural, financial presence in its homeland. So I was told you're a good lawyer, and I heard, the lawyer should be doing something about this. What can you do? Well, the background speaks for itself, the history speaks for itself. Clearly, Armenian nation, we are entitled to beyond reparations for what has happened. But in 2016, more than 100 years from the date the crime was committed initially, even though I believe it's a continuing genocide throughout the era of the Republic, where do we go? Who will give us the remedy? I'm a lawyer. I have to file papers. I have to find a courtroom. I have to have keys that open that courtroom door. What that means is I need a court that has jurisdiction, has power to make a decision and enforce it and make somebody actually pay. Then I have to find people. Once I find that court, the people, the client that I'm going to represent, even though everybody believes, yes, of course, like other clients we get in our normal business. Somebody committed fraud against me, go to court and, you know, get my justice. Well, I need to have a client that has standing to be in that court. In other words, to be allowed to present a grievance to that judge who can make a decision, then you can send the sheriff out to enforce it, right? So we need to have standing. So we look around. We've done cases, not my personally, but we're talking as an Armenian nation every time I say we, in the United States. And you know the story. We've worked very hard. Some of them went all the way to the Supreme Court on the, you know, the last life insurance case, the Reparation Armenian case. And for political, legal, whatever reasons, we didn't get our justice. So my part, I'm going to talk about Turkey because that's where the crime was committed. So logically, a court that would have the most direct jurisdiction over this would be in Turkey, even though, of course, the government is the responsible party as well. And then Karnik will talk about the international law remedies. We will converge, and as I will get to it at the end, but they do converge. In other words, we could start in Turkey, and we could meet somewhere outside Turkey as a final arbiter, and it's an international arena, and that's where I'm going to leave it off, and he's going to take over. Again, our biggest enemy is time. What can a Turkish court do, assuming that they are fair, right? I mean, it's a big assumption. Well, Turkish government put notices up saying, you know, we're relocating you, get ready, tomorrow you got to leave your home. I mean, I'm going to do this fast forward, very non-intellectual, so bear with me. So they put signs up, they say, all your property has to be listed and entrusted to us. We are the trustees. For war purposes, you're being relocated to another section. And as far as I know, and I could be wrong, over 60 giant books containing that information, that documentation, inventory, land, property, cash, all that has been entered. 66, 67 giant books. Still, nobody can see them. Nobody knows where they are. It's top secret archive material in the Turkish government. Of course, that relocation, very soon, legally, they're already ready with the legal work, which indirectly is, of course, another major proof of the genocide, that why would they have these very sophisticated, elaborate laws ready to be struck in June 1915, September 1915, and on and on and on. They start using the term abandonment, right? So these properties that were supposed to be entrusted, and when the war is over, you get back to your home, and I'm going to give it back to you, turns into abandonment. And later on, during that 1920-23, the General Congress time, and right before Lausanne, as a republic, even the word fugitive is added, like fugitive abandoned property. So not our citizens whose property we are holding in trust. Now they're fugitives. And people who didn't help us in the war of our independence, they are also to be sort of dissed. They're not getting anything back. So how is, assuming you have deeds and titles in your hands, which is not that many people, and you're a descendant of one of those individuals who were killed, mostly, few survived, go to a Turkish court today and say, I want this back. But the problem is the laws that they passed, first allowing this confiscation and conversion of the entrusted property either into the treasury or being sold off to Muslim immigrants that are being located there from the Balkans or from Circassia. And somehow claim, that we are here, I file a lawsuit and I want it back. Well, under their laws that sort of reversed that during the era when Turkey was occupied by the Allies, that was, withdrawn. But it was again re-implemented, especially when the Republic quickly took the personality of the Ittihadist regime that was in charge at the time of the genocide. The CUP mentality, of course, the only native ideology of Turkey, which has a tendency to come back from time to time, including recent times. So that law, and they made most of the changes that would prohibit people from actually going to court and say, I want my land back. I think in the month, I could be wrong about this, and we got much smarter people here. I believe in June of 1924, 2 months before the Lausanne Treaty was signed in August of 1924. So they went to Lausanne, just making sure we're not going to let Armenians come back and claim their property. And then, so under their laws, there isn't a remedy. But maybe there is the Lausanne Treaty, right? The Lausanne Treaty says, Armenians, and they can come back. Time was given for those people to come back and claim their properties. In some cases, 6 months. In other cases, a year or two. But in reality, they actively prevented the few people who actually were aware of this and tried to re-enter Turkey to then claim the property under the provisions of the Lausanne that allowed anybody who used to be a citizen but now is outside Turkey, right? The new Turkey excluded Syria, for example, right? And Syria was part of the Ottoman Empire. So there are provisions that allowed non-Armenians, but it's a neutral language, but some of the non-Armenians, Muslims in Lebanon and Syria were able to get property back if they owned it as Ottoman citizens. Now they're in the extracted part of the empire. But Armenians were actively prevented from entering. They were hassled. There's newspapers writing all sorts of bad things about Armenians during that time. So of course nobody claimed. But there are many other provisions. And Lausanne Treaty is law in Turkey. We have to remember that. That's one. It's a treaty that they signed. In a different context, we have issues with the Lausanne Treaty, but in the context of going to a Turkish court and saying, one of the laws that you must apply here, Mr. Judge, is the Lausanne Treaty, because a treaty is law. It's supreme law. The only maybe constitution is the one that it could not supersede. So, you could say, and this is a very esoteric legal thing, and since the time has passed, it's been 100 years, right? And they'll say time under Lausanne was up in 2 years from the date it was signed. Is the argument what the lawyers' technical term called estoppel, like saying, well, you have unclean hands, Turkish government, so you cannot use time, passage of time, as a defense on an otherwise legitimate claim. I have a title, this is my property, it was taken from me, and the reason I couldn't come back and claim it within that time period was you actively prevented me from coming back. So obviously the Turkish courts would not, probably entertain that, but that's one avenue. What's been really going on in Turkey? Because you hear that there are lawsuits. Some of them are successful. Well, the only few successful lawsuits that I'm aware of has to do with properties taken after 1936, when Turkey issued a major proclamation taking away most of the Armenian foundation properties, our communal properties, church properties, schools, orphanages. They owned a lot of property. So in the 40s and 50s, what was taken, a small percentage was either given back, maybe 6 or 7% by government, or few cases, if any, have been actually successful with a final decision and return. There are pending cases, and we've heard some good stories. The only one that actually got some attention was the lawsuit filed by somebody LA-based, I believe Sujian family is the name, about the airport in Dikranagert, in Diyarbakir. But that was not a substantive decision. It didn't, in other words, in 2012 or 13, the court didn't decide to say, okay, we're giving you back your property. Because it's giant property outside Diyarbakir, it's an airport now. Well, what they said was, because the government said, it's too late. Remember that argument? You can't even come here. So it involved a time issue. And because the zoning was changed in 1967 from what it was, let's say it was farmland. It was taken as a farmland from the family back in 1915. But in 1967, government made a zoning change to allow an airport to be built, to say this is no longer farmland, it's going to be airport land. So, and the lawyers representing the family were able to prove to the highest court, not the constitutional court, but the Court of Cassation, because unlike US, they don't have one Supreme Court. So the highest court, other than constitutional issues, ruled that yes, they didn't give proper notice, government didn't give proper notice to these owners when they made the zoning change, so the case can be sent back to the lowest trial level to start actually the substantive part of the case. And all the other time arguments may still be applied. But I've looked into it, I've read, I've asked anybody I could reach, but maybe, unless I'm missing something, some super secret decision that nobody knows about has been made in the last 2-3 years, there's no action since the Court of Cassation sent it back. Other major cases, of course, there was a lawsuit filed but then withdrawn by the Patriarchate on the Sansaryan Foundation's properties, one in Istanbul, which was the old famous, infamous police headquarters of torture and all that, and then, of course, the Erzurum property, that was the school itself. That was withdrawn, and I don't know about Istanbul. Maybe there is some sort of a settlement to happen, but there has been no court decision that gives the property of the Armenians back so far. Then the communal lawsuit you know about. Our church, the Catholicosate of Sis, has filed a suit for the properties belonging to the Catholicosate. And those are, I mean, of course, it's church property. You would think there should not even be a statute of limitations. Who else can a church property belong to but the church itself? But, of course, it's Turkey. So it's filed in a different, interesting way. The lawyers, for strategic reasons, picked not to start in the street-level courthouse, where normally you go and say, I want to get my property back. They went straight to the Constitutional Court of Turkey. All I know is the court didn't throw it out. I mean, in other words, they accepted the filing. They put a stamp on it. So it's accepted. That means that they're supposed to make a ruling on it. But so far, at least I am not aware of any ruling. But these need to be made. The Patriarchate has a lot of property there, and there is one problem you should know. When, after Patriarchate was reinstalled the second time, because in 1916 they closed the Patriarchate down legally, that was flipped over to Sis, their jurisdiction, and then Sis was closed, and eventually Patriarchate was reinstated back the second time. And they came back. But when the Patriarch returned, the government no longer recognized the legal status of the Patriarch. We have an Armenian Patriarch, individual, but they don't recognize the Patriarchate's legal status the way it always was and legally since the 1861 and 63 Armenian constitutions and the laws in the Ottoman Empire. So Patriarchate may or may not remember standing. I said, who goes and says, I'm suing? Can. There are churches that can, because each church has its own foundation. Remember that 6 or 8% that I mentioned? They got their property. Yeah, they were returned property. Karagözyan orphanage got a major property returned to itself. But again, nothing by court ruling. And if we go beyond our legal issues right now and say what is really going on, well, we had some good period, 2011, 2012. It looked very hopeful that we actually could go to courts and maybe get some justice in Turkey. But so far, it looks like that was minimal, and it may have been a sort of a face-saving phase heading to April 24, 2015 by the government, and because they needed some sympathy in the world. Because if you look at what's been going on since April 24, 2015, there has been no action on any of the cases. Government has been much more on the offensive against the Armenians, you know, even though up until that point there still was denialism, but the denialism's dosage had been reduced. But since the 100th anniversary, the dosage is up. And recently I just read they are challenging Armenian properties that are legally owned. Surp Takavor Church in Kadıköy, one of our main churches which owns this. Kadıköy is the second largest part of Istanbul, the Asia side's main city. They own a lot of stores there. And now there is a revolt brewing by the tenants saying the Armenians are gouging our money, this and that. And we never heard these things before. So there is, and I don't need to tell you what's going on with regards to southeast, the Kurdish areas, and Diyarbakir. One thing though we should know though, there was a lot of misinformation on both sides. The church in Diyarbakir has not been confiscated. The property around it has been nationalized. But of course, what could follow may be similar to, you know, the legalities that we confronted. Remember the Armenian properties given to the migrants, the Muslim migrants from the Balkans and Circassians at that time? The Kurds may be facing the same thing, where their properties would be nationalized, and maybe those Syrian refugees are going to be settled in historic Armenia, the Sunni refugees. But why do this? Why am I talking about this whole thing? In the old days, it's very hard for an Armenian to go to Turkish court and say, first of all, you need to face psychologically the issues of, you know, these are the people that butchered our people and, you know, removed us from our homeland. Why should I go? Because I got to go claim I am a citizen, I'm here, I need relief, I need justice from you, Mr. Turkish judge. And that was very hard. And it had no real reasonable expectation of recovery, because it was going to end in the Turkish court system. So you sue here, you lose, you appeal to mid-level, you appeal to the highest level of Turkey, and you lose, which was a guarantee, and you'd be out. So why go through that whole thing? Well, one thing changed. Turkey is a candidate for membership in the European Union for various reasons involving that. Turkish court rulings are subject to review by the European Court of Human Rights. So you can appeal an adverse decision, a negative decision, to the European Court of Human Rights. And it is for that reason, given all of our options as lawyers sitting in for actual remedy, we think that we need to pursue it, because at least we're going to get some sort of a ruling by a more fair and balanced and favorable court in Europe. So with that, I'm going to flip it over to Carnegie to pick it up from European Court of Human Rights. Thank you.
Well, today we're going to talk about dignity. Okay, I understand that we're not all lawyers here, so you're going to have to bear with me because we're going to have to get through some actual cases, because at this stage, the question in front of our nation is a legal question. So it's important for us to cover quite a bit of cases, and we're going to go through it, leaving off where Edvin talked about the European Court of Human Rights, and we're going to explore this in two different angles. One is a substantive angle, and one is a procedural angle. And we're going to be focusing on what we can do in terms of reparations and restitution, with the goal that we're going to try to uncover some concrete steps that we can take. All right, well, let's start with what the genocide is, right? And I'm not going to give you a legal definition of what the genocide is, but I want to talk about what it does, what it has done, and as Professor Terrio had mentioned earlier, the actual scale of the impact it's had on us as Armenians. It's clearly a national trauma, and with most traumas, you have a post-traumatic period. We're in that post-traumatic period. We've been in that post-traumatic period. And just like with post-traumatic issues and down the street, you hear of people coming back from wars, we cannot ignore what impact that trauma has had on the psychology of our own identity. We can't pretend that the last century's discourse of disenfranchisement hasn't utterly consumed and perhaps even confused our own view of our own identity today. Now, it's axiomatic. We know that we are more than the genocide, but trauma skews that. It blurs the horizon for us. You see, it's the purpose of genocide itself to erase the people, to erase the nation in the minds of the people who remain, and then to erase everything else from the national identity of the rest of us. It's an uncomfortable truth, but this is what it does. And reparations are supposed to fix this problem, right? But we have to think about it. Where does it come from? Where does the idea of reparations come from a legal perspective? And it comes, oddly enough, from a nitrogen factory in Czarzow, Poland. And this is what the promise of reparations is at international law. From a positivist legal angle, this is the case they look to tell us what reparations mean. And you can see, let me tell you a little bit about the case. This is a 1928 case involving the Silesian uprisings, not Giliga, not Silesia, but Silesia between Germany and Poland in 1922. And parts of Silesia were taken from Germany and awarded to Poland in 1922. So Germany sued, and states at that time didn't have the International Court of Justice. They had something called the Permanent Court of International Justice, which is its precursor. So they sued in the Permanent Court of International Justice in 1928 and argued that reparations must be paid for the damages they sustained from the fact that this very important nitrogen factory ended up in Polish hands and not German hands. And what the court said was, and the quote is up there, reparation must, as far as possible, wipe out all the consequences of the illegal act and reestablish the situation which would, in all probability, have existed had that act not been committed. Now that sounds perfect, sounds great, it makes sense to us, right? Something's taken, we're going to put it back to the way it was before it was broken. That's what reparations is. We have that model in English common law and in the US and in many other countries. Now, this should be rather straightforward, but it's not. And the reason it's not straightforward is that the ICJ, which is that beautiful picture at the top with all those judges, the ICJ is a form of states, not people. In other words, you can't argue as an individual in a case in front of the ICJ. Very few people can, because as a form of states, the only people that have a right, or the only entities that have a right to appear in front of the International Court of Justice are nation states, as the professor was talking about earlier. So what do we have? We have the Republic, yes, and the Republic is a legal entity in international law. And therefore, in large amount, we as a diaspora, we as Armenians living throughout the world, have to rely on the Republic to obtain ICJ jurisdiction, International Court of Justice jurisdiction. Now there's some other theories on how you can use other states and piggyback on other states, but that's an issue for another discussion. But what's really interesting, and as Professor Terrio was mentioning earlier, there are a lot of problems with the Republic, and this is not a political statement, it's a reality statement. We have systemic depopulation, we have corruption issues, we still are unable to recognize the independence of Artsakh. There are a lot of things on the Republic of Armenia's plate. It's a burdened state in a lot of ways, both internally and externally. So we can't end the thinking about what happens to us there. And if we think about it, we are uprooted. Territory is just the beginning of what was lost. In fact, it's interesting that today, the genocide itself may be the single most commonly shared trait of group identity that we have, particularly outside of Armenia. Even a quick survey of those who we consider Armenian or consider themselves Armenian quickly demonstrates that it is entirely possible that neither language, location, vocation, cuisine, culture, or even religion links one Armenian to another to the extent the genocide does. This should disturb us. It should frighten us that we're left holding more hands in our trauma than in our dances, left sharing more pride in our protests than in our literature, and left embracing one another more in commemoration than in celebration. You see, we're not living in a sustainable situation. The fibers of this tree are not going to live forever. And it comes down to then, if we think about issues of group identity, human dignity, we are dealing with an issue of dignity. How, when, where, how do we litigate issues of dignity? It's not the ICJ, it's not the International Court of Justice. Dignity is not part of the ICJ's jurisprudence. They don't talk about dignity. Their cases don't deal with dignity. That's a form of states. That's where states argue state issues. And there are ways we can be there. But our issues are even bigger than territory. Territory is just the beginning of what we've lost. So, following up on what Edvin had mentioned earlier regarding cases that come through the Turkish court systems, and particularly the Constitutional Court of Turkey, the place where we have to litigate dignity is, quite frankly, the European Court of Human Rights. And in particular, the European Convention on Human Rights, Article 8, Paragraph 1. It's one sentence long, and it says, "Everyone has the right to respect his private and family life, his home, and his correspondence." Wow, that sounds pretty ambiguous. What in the world could that have to do anything with the Armenian genocide? It sounds a little bit like the U.S.'s right to privacy, perhaps, I don't know, some constitutional rights with respect to family life and, the freedom to think of things and things of that nature. And I'm sure that the cases are really, really old, and there's really no meaningful thing to really kind of grapple, hold on to and say, well, we're going to litigate dignity, and we're going to litigate dignity using that sentence. Well, we're going to have some fun with some cases because I think you'll find this entertaining. We're going to talk about a case involving soccer with the Gestapo. And this is a case called Putistin versus Ukraine from 2013. And in this case, the court accepted the idea that the reputation of an ancestor, so your ancestor's reputation, could in some circumstances affect a person's private life. Now, if we look back for a second, private life. And in that case, it found that a newspaper article about some football match, that Mr. Putistin's late father participated in, who was a really well-known soccer player, and took part in that match. And because there were players in that match that were also part of the Gestapo, he said that that newspaper article had had affected the reputation of his ancestor. Not only did he say that, but he said that that violates his rights under Article 8, Paragraph 1 of the European Convention of Human Rights today. That case is from 2013. This happened 75 years ago. So you have a present day individual filing suit under Article 8, Paragraph 1, saying that what you said about my grandfather 75 years ago affects my rights under the European Convention on Human Rights. Okay, well, it's a good start. Let's see here. Those who can read Turkish will get a kick out of the word there, the name of this book. Okay, I'll do a pleasant translation. It's a book by Professor Ali Rafet Özkan. Okay, and his book is entitled The Gypsies of Turkey. Okay, and it was published by a government publishing house. And in this case, Mr. Aksu, that's not Mr. Aksu, that's the professor and his book next to him. Mr. Aksu was complaining of these publications that the government, that a publishing house by the government sponsored by the government of Turkey had made. And in this book, there were harmful pictures. You know, there were pictures of gypsies, of Roma people in Turkey. And there were statements made that the professor made saying that they were stingy people, fraudulent people, they were aggressive. But it wasn't so much the picturesque language, but it was the fact that Mr. Aksu had sued under Article 8, Paragraph 1, saying that those statements in that book about these people, the gypsies, harmed his dignity as an individual. And the court actually agreed. And it said that the negative stereotyping of an ethnic group was capable, when reaching a certain level, of having an impact on the group's sense of identity and on the members' feelings of self-worth and self-confidence. So the court held that those statements, those negative stereotypical statements, a lot of which Edwin alluded to, even happening today, can affect their private life and therefore violate his rights under the European Convention, Article 8, Paragraph 1. So, again, we look at the date of the case. This is 2012. This isn't a case like I showed you before with the nitrogen factory from the 1920s. This is happening today. This is probably the most interesting one, especially for an Armenian American audience. The dignity jurisprudence, the use of Article 8, Paragraph 1 to litigate dignity is really, really broad. And it turns out that it doesn't even have to be in a newspaper. This case, Genocide versus Slovenia, 2014, okay, this is interesting, involved a work of fiction. In other words, it was a made-up story. And in 1998, a writer self-published a novel describing the life of a woman beginning in the 20th century who married from the Slovenian countryside, who moved to America, married a handsome Slovenian guy, and took over the family farm and was very successful in America and this and that. This happened back in the 20s, the story says, right? It's not a real thing, it's a story made up. And the main character, a Slovenian woman, right? The book describes her as her name was Rosina, by the way. She had used sex to get her way with her husband, sold illegal alcohol during the Prohibition period, and valued money over her children. That's what the story, this is a character in a story, right? So this character in the story this is how they described her. So Genocide and others had sued Slovenia in in their courts and ultimately the European Court of Human Rights, saying that the story kind of sounds like somebody that I knew, sounds like kind of one of my ancestors. You know, we're country people. We came from the countryside. We came from the countryside near where your story is based. And the court actually said that an attack on the reputation of an ancestor, even in a work of literary fiction, comes under the ambit of Article 8, Paragraph 1 of the European a European Convention on Human Rights. So, language affecting the reputation of an ancestor is actionable under Article 8 of the European Court of Human Rights, even in a work of literary fiction. Okay. So why do we care about these cases, right? They're interesting to talk about, the pictures look nice, but why do we care about these cases? Well, we care about these cases because the court in Perenchek actually cares about these cases. In fact, they cite those three cases I just mentioned. And why they cite them is that they say that Armenians have a group identity that is shaped by their belief that they are victims of the genocide, and that is a protectable right under Article 8, Paragraph 1 of the European Convention on Human Rights. That's pretty big. The court stated, and I'm quoting here, that as the Swiss federal court in point 5.2 of its judgment, many descendants of the victims of the events of 1915 and the following years, especially those in the Armenian diaspora, us, construct their identity around the perception that their community has been the victim of genocide. And he said that the Swiss law, we all know what happened with the case in terms of the Swiss law being overturned, but that the Swiss law was intended to protect that identity, and thus the dignity of present-day Armenians. So, while the case didn't come out the way we wanted, which is why Mr. Perenchek is smiling, he's smiling too early. He's smiling too early because you have to read the entire opinion. And it gets worse for Mr. Perenchek. In paragraph 227, the court actually made the link that I was talking about. In the answer to the question of whether such a necessity exists, depends on the need to protect the rights of others. In other words, today we are protecting the rights of our ancestors, and that becomes a protectable right under Article 8. As noted in paragraph 156 above, the previous slide, these were the rights of Armenians to respect their and their ancestors' dignity, including their right to respect their identity constructed around the understanding that their community has suffered genocide. Okay? And the court actually says, in light of the case law, the woman in the scantily garbed clothes walking around, during Prohibition selling, they cite those cases to say that Armenians have a right of collective identity around their understanding of the fact that they are victims of genocide. And the connection that right to protect the dignity of their ancestors and for self-respect, and what all those cases are saying, is something that's actionable under Article 8, Paragraph 1, of the European Convention of Human Rights. And this is not a case from centuries ago. It's not even a case from a year ago. And it's a case that deals with our issue specifically. So the court has made the link for us. Okay, so let's pretend that all of that makes sense and we're going to litigate something, right? We're going to take it through the Turkish courts, the Constitutional Court, and we're going to take cases up to the European Court of Human Rights. How in the world are we supposed to do that? Because the caseload is unimaginable, and it's probably unmanageable. And what's interesting is that, we got these pictures. Where do we start? I mean, there's the churches of Ani, there's the issue of Ds, there's the issues of degradation of grave sites, comments that Edwin had referred to regarding sedition, being traitors, being thieves. I mean, where would we start? It would seem that it would be an impossible task to undertake. It's interesting because we're going to start here, again in Poland, at the Bug River. This is what that river is called. It's called the Bug River. And the reason we're going to start here is because the European Court of Human Rights in 2004 made a very interesting analysis of what was in front of them with respect to a bunch of cases. Now, let me give you a little bit of history, and it's kind of odd how a lot of Armenian-related case law takes us back to Poland for some reason, but here we are. And in the aftermath of World War II, okay, the what happened was that Poland shrunk. You see that gray part over there, what used to be part of Poland before World War II. After World War II, it shrunk, right? So the Polish state agreed to that little white portion over there. The gray area over there went to the Soviet Union. In fact, it went to Lithuania, which is the part on the top, Yellow-Russia right there in the middle, and then underneath that it went to Ukraine. So what the Poles said is that, okay, well, all of you Polish people that are repatriating now, coming to Poland, you know, you're leaving your houses, you're abandoning your houses and leaving your property and all that kind of stuff over there, right? We need this deal to go through. We need our borders drawn and finalized. So what they said is, okay, well, we're going to compensate you, right, for the stuff that you've left, and you left it all in those areas that are now part of the Soviet Union. So we're going to compensate you. Come over here and we're going to compensate you. Now what's interesting is that the European Court of Human Rights started getting cases. They started getting cases, and Broniowski is one of the individuals that made that suit. But there were many of these cases. In fact, 80,000 people were in this situation, where they had given up all this land, come over here, and they were waiting on these promises by their state, the Polish state, to get compensation for their properties. So what the European Court of Human Rights said is that, well, you know what, all of these people, and the lawyers in the crowd will understand, are similarly situated. They've got the same problem, you know, they've got that same structural problem. There's a problem with Polish law that is not allowing these people to get what they need, what they were promised. The same structural problem. So what the court said is that, you know, we're not going to look at these cases individually. We don't have time for that. We're too busy. We're going to look at these all together. Now, it's not exactly what you would understand as a class action, but it's very close. The concept is the same, saying that we have all these cases. We're not going to deal with them individually. So the court liked this process. In fact, it liked it so much that it codified it. In other words, it made it a rule. Rule 61 says that when there is structural deficiencies in a contracting state giving rise to a number of cases, we're not going to hear all those separately. We don't have to hear all those separately. We're going to take a test case. We're going to take a lead case, and then we're going to adjudicate on that. And what's going to happen then is that the decision that we render is going to apply for all those people similarly situated. In other words, they're going to deal with systemic violations. In other words, you know, Digin Vartanyan, who lives outside of Cleveland, Ohio, doesn't have to bring her own case. That, like they did in Broniowski, there were 80,000 people in this situation. And then if you look at this case law and you say, well, yeah, maybe it deals with that property issue, but really, how often are they really using this procedural rule to get something done? Well, what you find is kind of shocking, because you find this rule, Rule 61, being used in cases involving titles and deeds. And I saw my little timer, so I don't have too much time to go into the details of these cases, but let me just say that here you had 20 Albanians, 80 different cases involving old titles of property that were confiscated by the communist regime in Albania. And the court said, yeah, you know what, we're going to use this Rule 61 procedure to say that there's a systemic problem with the way Albania is handling these cases that are the confiscated properties, and because of that, we're going to rule on a Rule 61 basis. Not only that, but there are cases that deal with old money and bank deposits. This is Suljagic versus Bosnia, 2009. Okay, where they said that there was a problem in terms of when Yugoslavia fell apart about the conversion of money. We had money in banks, they were saying, that when you converted to, you know, we became Bosnian citizens all of a sudden, and now our money's worthless, you have to do something. In fact, there were a lot of cases like this, or the court expected a lot of cases like this, and said, you know what, we're going to handle this together. We're going to handle all of these cases together. In fact, in that particular one, there were 1,350 cases like that. It's been used, this Rule 61 has been used in cases involving nationalized properties. In Atanasiu versus Romania, which is a 2010 case, the Romanian communist regime had confiscated properties, okay? And after 1989, numerous Romanians had sued for compensation or restitution. This is one of the royal residences, actually. And the court ordered that the plaintiff can proceed under Rule 61. In other words, all of it together. All of these cases can proceed together. Enforcement delays. Edvin spoke earlier about the fact that there are cases that have been filed that are just sitting there. Well, in Burdov versus Russia, the court found the same problem with a bunch of judgments on debts that were ruled on by, that they were valid judgments by administrative decisions, but nobody was able to collect on these things. So the court actually said there were 200 cases that it noticed had been coming in since 2002, and said, you know what? There's not a sufficient system for redress. So the court ordered the government of Russia to put in laws that would allow for this, and then to come back, which is another part that's really important for the court, to come back and prove to the Council of Ministers of Europe that the law that enacted is actually going to do the trick. So you have European Court of Human Rights monitoring. And finally, the other thing that's really interesting is that this Rule 61 has been used for cases involving the erasing of people. And this is language that's used by the European Court of Human Rights. I'm not trying to make it more, dramatic, okay? And they define the group of erased people as a group of former nationals of the former Yugoslavia who lost their status as permanent residents following Slovenia's declaration of independence in 1991. So Slovenia declares independence, they lose their citizenship. In fact, the number of erased people in 1991 was around 25,000, and there were still 13,000 of these people without any status living in Slovenia in 2009. The court looked at this and said, you know what, we're not going to take individual cases like this, we're going to take them all together, because it makes sense. So if you look at, and I'm kind of flipping through kind of quickly here, but if we look at the elements of our indignity, right? We're dealing with erased people. We're dealing with titles and deeds. We're dealing with monies and bank deposits. We're dealing with nationalized properties. And we're dealing with delayed enforcement. Our indignities, these elements are the same indignities. This isn't legal theory. These are not old cases. This is actual jurisprudence. These are actual cases from a couple of years ago. And what's very interesting about this is that these are cases that are cited in parent check. This isn't from, I just didn't sit there, thinking I'm going to do some research and make this kind of interesting. These are cases that a judge sitting in Europe making a decision on issues involving the genocide, said that he cited those earlier cases. So, in the same way the world really does look upon us now and says why we haven't pressed a legal case for Artsakh independence in the last 20 years, they're going to ask, 20 years later, why we didn't actually read the parent check opinion. They're going to ask, why didn't we look into that case law that the court cited for us? And then they're going to say, why didn't we think of redressing these indignities through a place that the court told us would be a pretty good place to start? And when we think about Article 1, Paragraph 1 of the European Convention on Human Rights, and the Rule 61 pilot procedure, which is that class action type procedure that the court has, we understand that parent check in the European Court of Human Rights gives us a really interesting foothold into something pretty remarkable. You see, parent check was not about Amal Clooney, the video on YouTube. It wasn't about that. It was about her. The dignity of our ancestors and our defense of their dignity holds the key. The court saw that we, the descendants of the victims of the genocide, have a unique identity that's shaped around those events. That we are a class of humans wronged, and even pointed us in the direction of Article 8, Paragraph 1, to protect that dignity and the myriad violations of that dignity. Now, I think it's important as us decision makers start thinking about the legal avenues that we think about these things as constructive approaches to taking action today ourselves. It's not always, there are avenues through the International Court of Justice, and this is an issue of another discussion. I'm going to just kind of in conclusion hit on a couple of just quick points. But I think that Parenchek, the cases that we cited, sorry, when I said her, I was referring to her. When I said it's not about Amal Clooney, but it's about her. Okay, so, you know, the dramatic effect was lost, but there it is. Okay, in any event, thank you. But I do want to kind of conclude with a couple of points that I think are important regarding the Artsakh situation, as well as ICJ, the jurisdiction that was discussed before, and I'm sure it'll come up in questions. But first and foremost, I think one thing that's important about Artsakh and statehood, right? We get confused because it's not medicine, you know, law is different because it kind of overflows into politics. The legal issue of Artsakh independence is really not a difficult, I mean, in and of itself, it's not a difficult one. Artsakh satisfies all the legal conditions under law for sovereignty and recognition of independence. The idea of recognition, however, is a political thing, right? So there's definitely some dovetailing that needs to get place, but I think it's important from a legal perspective to understand there are very few jurists out there that would argue that Artsakh having constitutional status, even during, not only, you know, during the fiefdoms that existed prior to the Russian Empire, but even in the Soviet Union had a separate constitutional status, and then its ability to control its borders and to enact laws and have a functioning government within the last 20 years itself is proof of its legal character as a sovereign state. The idea of recognition, which is something that we need to push others, organizations, and states to recognize, is a political one. The legal question is really not that difficult. The other issue is, we talked earlier about the, you know, I think one of the obstacles for, you know, and I too find the Wilsonian Award a very exciting approach, but there are kind of legal obstacles I find, and in particular, and Armin had raised this issue with the idea of estoppel, and you know, maybe during question and answer we can talk about that, but there are 4 cases involved. There's one involving Cambodia and Thailand in 1964, the status of Eastern Greenland in 1933, there's Denmark and Norway. There are a number of cases that deal with the issue of estoppel, meaning that President Sarkisyan's statements back in April and then more recently, that those can be used as a mechanism by which to invoke estoppel and say that since you haven't claimed, since you haven't said, in fact in this particular instance have said that you do not have any claims, that you would be barred from bringing that case forward, or it would be dismissed on those grounds. That being said, the situation of Artsakh is very different in that because you are fighting and making declarations with respect to the land. So I think that there's an important distinction there regarding how our lands in Western Armenia have been treated by the state vis-a-vis the Artsakh model. So we'll take questions later, but thank you again.
With my thanks for the morning panelists, Professor Thorio and Your Honor, Mr. Papian, and my beloved Armen Hovhannisyan for his superb moderation, I will now turn it over to you to ask questions of these 2 gentlemen. Yes? No? What do you mean? No, we're not going to be here at the end, some of us. We have a wedding to go to, so just like the first panel, we're going to take questions now. We're going to take questions out of it because some of us have a wedding to be at 5 o'clock. Okay. I'm going to ask Mr. Papian and then Harut. Go ahead, Harut. Thank you.
Thank you. I have 2 short questions.
Sure.
The first one is I believe that Mr. Cronin said, if I heard it correctly, that the European Court of Human Rights on the Parenchek case overturned the Swiss law. If that's what you said, it's not accurate. The law was not overturned. The court ruled that in the Parenchek case, the Swiss law was not applied properly. But the Swiss law was maintained. In fact, last week, the Federal Court of Switzerland reiterated that the Swiss law needs no change under the European court decision. The second one, the 3 cases that the judges cited, they're very interesting. I wasn't aware of them. Can you tell us if those 3 cases are cited by the majority decision or the minority filing?
Yeah. To answer your first question, what they were doing was doing a balancing test, right? They're asking, you know, in the U.S. model, basically the right to freedom of speech, how the right to freedom of speech would balance against the Article 8 protections provided in the European Convention. So you're correct with respect to the overturning issue, but the issue was really the balancing of the tests, and that is the subject matter of what I was talking about with respect to the identification of the group identity issue under paragraph 227. Okay, the cases are cited in the majority, by the way, and it's paragraphs 200 to 203.
Baron Papian.
A lot of Armenians has properties in Tbilisi, in Baku, especially oil fields. Can descendants of the owners of these oil fields sue based on Rule 61? Can we go against Azerbaijan, Azerbaijan, especially oil fields? Because a lot of descendants are alive and they have documents.
Just to be clear, Rule 31 is a procedural rule. It's a mechanism. Sorry, Rule 6. What did? 61? Rule 61. Yeah, did I say 16? Sorry. Yeah. Rule 61 is a procedural mechanism whereby cases can be consolidated, right? So can they? The mechanism exists for nationalized and confiscated properties. So to answer that question, yes. The main question in bringing cases like that are whether or not the violation that's complained of has to violate two things. It needs to violate the constitution of the contracting country, in other words, the state. Right. So in other words, the violation that was taken, that was caused, you have to have a link within the constitution of Azerbaijan, for example, to say it violated something, right? And then it has to also be a violation of the European Convention at the same time, right? So you have to have those two links. So if you're able to do that, you can bring it to the Constitutional Court. You'll probably get an adverse ruling, and then you can appeal it to the European Court of Human Rights. And you'd be surprised at how many cases. You know, Turkey is a very famous player in the European Court of Human Rights, as is Azerbaijan. There are quite a number of cases against both of them. There's plenty of jurisprudence involving those questions. But to answer your question, the way to do it would be to find a substantive violation of both the Constitution of Azerbaijan, or the laws of the state, and as well as a violation of the European Convention. If you can bring a claim that identifies those two areas, then you'd be in the right path towards the European Court of Human Rights.
Thank you, Karnik. Thank you. Any other questions? Seeing once, seeing twice, seeing none. Yes, last question.
This is for Mr. Minasian. The recent news about the Armenian church at Diyarbakir being seized, you mentioned that it was the property itself, not the church. Is that a national act?
Right.
Is that under eminent domain type of thing that the Turkish state uses? And don't they have a right duty to pay the owner of the property?
Right.
Use the other one.
Yes, if it's private properties, of course. It is eminent domain. But some of it is apparently from the municipality. What they turned it into state, some of them are streets. Imagine we are in this church, right? You know, Glen Oaks Boulevard, Verdugo, and all of that. That's what they made public property. And that apparently belonged to the municipality of Diyarbakir, or Sur, the actual city. So if within it they seized properties from individuals, of course. All I was saying from the Armenian end is that the title to Sırp Giragos Church still belongs to the Sırp Giragos Foundation in Istanbul. And that has not been taken.
Thank you, Edwin. That concludes this panel. I look forward to the last panel, the representatives of the Armenian political parties. Thank you very much.